Welcome to Simplified UPSC by PPP, where we listen, learn, and grow together. Detailed lecture notes in English and Hindi, plus practice questions for prelims and mains, only on our Telegram channel. Link in description. Like and subscribe for more.
Welcome to the deep dive. Our mission today is, well, absolutely crucial. We're providing you with the essential blueprint for understanding India's environmental governance.
That's right.
We're aiming to cut through the complexity, the jargon, the timelines, to give you a really strong conceptual and factual foundation. We want to explain the why, the when, and the powerful how of India's environmental acts and policies.
And this really is foundational stuff. We're blending the, let's say, philosophical mandates you find in the Constitution with the hard legal facts, the acts, the policies.
So precision is key today.
Absolutely. We need to be precise. We'll be focusing on specific years of enactment, key constitutional articles, the crucial institutional architecture. Think of it as building that core knowledge base you really need on this critical area of Indian governance.
Okay, so how are we structuring this?
Good question.
We'll start with the constitutional grounding, the fundamental why, you could say.
The base.
Then we'll move chronologically through the milestone acts, kicking off with wildlife protection back in 1972.
Right.
We'll definitely spend significant time unpacking the so-called Umbrella Act, the Environment Protection Act of 1986.
Can't miss that one.
We'll also examine the specialized power of the National Green Tribunal, the NGT.
Yes.
And we'll wrap up with India's overarching national strategy on climate change, the NAPCC, detailing its ambitious core missions. Okay, let's dive in. So before 1976, environmental protection. It wasn't explicitly centrally integrated into the Constitution, was it?
No, not in the way we see it now. I mean, there was awareness, sure, but it lacked that specific legal weight within the core document itself.
And that all changed quite profoundly with the 42nd Amendment enacted in 1976.
It really did. And you said this wasn't just some minor legislative tweak. It signaled a major conceptual shift, a commitment.
Making the environment central to the nation's identity, both political and civil.
Exactly. And it did this by distributing responsibility sort of across two key spheres within the Constitution.
Okay, walk us through this.
So the 42nd Amendment touched upon two distinct, but definitely interconnected areas of constitutional law. First, it addressed the state's obligation.
The government's job.
Right. And that's found in the Directive Principles of State Policy, the DPSPs, specifically Article 48A.
Article 48A. And what power does that grant? Or maybe what does it direct the state to actually do?
Well, Article 48A mandates that the state shall endeavor, that's the key word, endeavor to protect and improve the environment.
Protect and improve, not just maintain.
Precisely. And it explicitly adds to safeguard the forests and wildlife of the country. It's a clear mission statement for the government. Improvement, not just preservation.
Okay, but here's a crucial point for listeners, right?
Yeah.
DPSPs.
Yeah.
They aren't justiciable.
That's correct. They are guidelines for the state when it formulates policies and enacts laws. You can't directly go to court and force the government to, say, improve the environment based solely on Article 48A.
So, if it isn't strictly enforceable in court before specific laws are passed under it, how much actual legal teeth did Article 48A have initially? Was it just aspirational?
It is aspirational in a legal sense, yes, but it's fundamentally important. It provides the, let's call it the legal and moral justification, the constitutional license, for Parliament to then pass the necessary environmental laws later on.
It frames the issue as a legitimate state concern.
Exactly. It puts it squarely on the agenda. But the 42nd Amendment didn't stop at the government. It also addressed the citizens directly.
Through the fundamental duties.
Precisely. By inserting a new provision there.
That would be Article 51 AG. What does this one demand from every citizen?
Article 51 AG is very clear. It states that it shall be the duty of every citizen of India to protect and improve the natural environment.
Similar language to 48A, protect and improve?
Yes, mirroring the state's endeavor. And it even defines the scope, including forests, lakes, rivers, and wildlife, and adds the responsibility to have compassion for living creatures.
Wow. So the takeaway here is really powerful, isn't it?
It is. The Constitution, post-1976, doesn't just treat environmental protection as, a top-down government policy issue under 48A, which is non-justiciable.
Right. But it also makes it a non-negotiable expectation, a fundamental duty for every single citizen under 51 AGU.
That's the core idea. It establishes this philosophical groundwork, the moral, the communal, and the legal license for everything that follows legislatively. This dual mandate, state and citizen, is really what anchors India's entire environmental legal structure.
Okay, let's move chronologically now to the first major piece of independent, centralized legislation specifically focused on conservation. The Wildlife Protection Act of 1972, the WPA. And the trigger for this, as you mentioned earlier, was pretty urgent, wasn't it? A rapid decline in wildlife.
Absolutely. India's wild animals and birds were facing serious declines. The existing state-level laws, well, they just weren't adequate to handle the crisis effectively. There was a need for a unified national approach.
And the WPA 1972 was a landmark, particularly given the legal setup at the time.
It really was. Because when it was passed, the subject forest, which explicitly included wildlife, was largely a state subject.
Right, under Entry 20 of List 2, the state list in the 7th schedule.
Exactly. So that presented a significant constitutional hurdle for Parliament wanting to enact a national law.
That is a hurdle. If it's a state subject, how did Parliament manage to get national applicability for the WPA? Didn't that risk stepping on states' toes?
It did create a novel challenge, legally speaking. Parliament had to cleverly use Article 252 of the Constitution.
Article 252, what does that allow?
Article 252 allows Parliament to legislate on a matter in the state list if the legislatures of 2 or more states pass resolutions requesting Parliament to do so.
Ah, so they needed buy-in from at least 2 states to kickstart it.
Correct. This mechanism was employed to overcome that federal constraint. It ensured the law could have national applicability, although technically each state still had to formally adopt it. But this centralization was absolutely critical for a coherent, unified wildlife policy.
Now, the Act is probably most famous for its schedules. Can you give us a quick rundown of how this classification system works?
Sure. The Act, as originally conceived, contains 6 schedules. They basically categorize species based on the level of protection they need.
Okay.
The absolute highest level of protection, think maximum legal safety, strictest prohibitions, and the harshest penalties for any violations, is reserved for species listed in Schedule 1 and Part 2 of Schedule 2.
And that's where we find the big names, the iconic species.
Precisely. Tigers, rhinoceroses, the great Indian bustard, the lion-tailed macaque,
Okay.
they all fall under this top tier. They enjoy the same maximum legal safeguard. It's about vulnerability, not just charisma. Even certain tortoises get Schedule I protection.
So it's genuinely biodiversity focused, not just megafauna. What about the other schedules? What do they cover?
Right, so Schedule 2, Part 1, and Schedule 3 list animals that are also protected, but perhaps not as critically endangered as those in Schedule 1. They still require significant protection, but the penalties for offenses are somewhat less severe. Schedule 4 includes animals that are protected from hunting, but the penalties are comparatively lower still.
And Schedule 5, that one's different, isn't it?
Yes. Schedule 5 is the vermin list. Animals listed here, like common crows or fruit bats historically, could be hunted legally. However, it's important to note that amendments have drastically restricted the power, especially of state governance, to declare any wild animal as vermin. That power is now much more centralized and scrutinized.
Good point. And finally, Schedule 6.
Schedule 6 shifts the focus from animals to plants. It lists specific endemic plant species that are protected, regulating their cultivation, possession, and trade. Things like pitcher plants, blue vanda orchids, red vanda couth.
Got it. So beyond just listing species, the WPA 1972 also provides the whole legal architecture for protected areas, right? Like national parks and sanctuaries.
Exactly. The Act empowers state governments to declare areas that have significant ecological, faunal, floral, geomorphological, natural, or zoological importance as either national parks or wildlife sanctuaries. These form the bedrock of India's in situ conservation network.
And weren't there later additions to these categories?
Yes, amendments, particularly in the early 2000s, introduced 2 more categories: conservation reserves and community reserves.
What's the difference there?
They offer more flexibility. Conservation reserves typically act as buffer zones or corridors connecting existing protected areas, often on government land involving local communities. Community reserves, on the other hand, can be declared on private or community land where locals are willing to participate in conservation efforts. It allows for greater local stewardship.
That seems crucial for buy-in. And the Act also established a key advisory body.
Yes, the National Board for Wildlife, NBWL. It's a very high-level statutory body, chaired by the Prime Minister himself.
The PM chairs it. Wow.
Yes, Its role is primarily advisory, advising the central government on wildlife conservation policies, and importantly, scrutinizing and approving projects in and around national parks and sanctuaries. Its recommendations carry significant weight.
Right. And you mentioned amendments earlier. The 1991 amendment was quite significant, wasn't it? Reducing state power regarding Burman, but also adding something about livestock.
That's correct. The 1991 amendment was pivotal. It almost totally withdrew the state government's power to declare wild animals as vermin, centralizing that authority. Yes, it introduced a crucial provision, mandating compulsory immunization of livestock within a specific radius of protected areas,
What was the radius?
a 5-kilometer radius of any national park or sanctuary.
And why was that immunization mandate so vital? What problem was it trying to solve?
It was a critical public health measure, really, aimed at preventing disease transmission. You often have livestock grazing near the boundaries of protected areas,
Right.
and there's a significant risk of diseases like foot and mouth disease, rinderpest, or others jumping from domestic livestock to vulnerable wild populations. Think wild ungulates like deer or gar, which can then affect predators like tigers.
So it's protecting the wildlife from potential diseases carried by livestock.
Precisely. It demonstrated a more holistic, ecosystem-based approach, recognizing the link between human activities like animal husbandry and conservation biology outcomes.
Okay, now we arrive at a piece of legislation where the link between crisis and legislative response is incredibly stark. The Environment Protection Act of 1986, the EPA. It's widely seen as the most comprehensive and, frankly, the most powerful environmental law in India.
Absolutely. And its origins are undeniably rooted in tragedy.
The Bhopal gas tragedy of 1984.
Exactly. That catastrophic industrial disaster laid bare just how inadequate the existing legal framework was. It revealed massive systemic failures in regulating hazardous industries, managing large-scale environmental risks, and crucially, enforcing liability when things went wrong.
The existing laws like the Water Act or Air Act were too specific, too fragmented.
They were. They dealt with particular types of pollution, but there was no single overarching law equipped to handle a multifaceted disaster of that magnitude, or to proactively regulate the whole environment. Bhopal created an urgent, undeniable need for a centralized, cohesive legal structure.
Which brings us to the core question people often ask about this act. Why is the EPA of 1986 commonly called the Umbrella Act?
It earns that nickname because of its incredibly broad, almost catch-all scope and the immense power it vests in the central government.
Broader than the specific acts before it.
Much broader. Unlike the Water Act, 1974, or the Air Act, 1981, which focused narrowly on those mediums, the EPA provides the central government with sweeping, generalized power. Section 3 gives it the authority to take all such measures as it deems necessary or expedient for the purpose of protecting and improving the quality of the environment and preventing, controlling, and abating environmental pollution.
All necessary measures. That sounds incredibly wide-ranging.
It is. If there's a perceived gap in existing environmental laws or a new type of environmental problem emerges, the EPA essentially empowers the central government to step in. It can make rules, issue regulations, set standards, and create notifications to fill that gap without needing entirely new acts of parliament every time. It acts like an umbrella, covering anything not specifically addressed elsewhere.
That's immense power concentrated at the center. What are some of the key regulatory powers specifically granted under this act?
The powers are really quite far-reaching. The central government can, under the EPA, 1, establish standards for the quality of the environment in its various aspects.
Like air quality standards, water quality standards.
Precisely. 2, lay down standards for the emission or discharge of environmental pollutants from various sources.
Setting limits for industries, vehicles, etc.
Correct. 3, regulate the location of industries and the carrying on of processes and operations.
So deciding where certain types of factories can even be built.
Yes. 4, it can order inquiries, conduct research, disseminate information, prepare manuals, codes, or guides.
Building the knowledge base.
Exactly. And crucially, it has the power to issue directions, including orders for the closure, prohibition, or regulation of any industry, operation, or process, or even stopping or regulating the supply of electricity, water, or any other service.
Wow, that's direct intervention power. Closure orders.
Yes. And there are 2 other provisions that really underscore its authority. First, it grants immunity to government officers for actions taken in good faith under the Act's provisions.
Protecting officials carrying out their duties.
Right. And second, and this is perhaps the biggest centralizing factor and often debated, Section 22 of the Act Debars civil courts from having jurisdiction to entertain any suit or proceeding in respect of anything done, action taken, or order or direction issued by the central government or other statutory authorities under this act.
No civil court challenges to EPA orders. That's huge.
It is. Any legal challenge typically has to go through specific channels, often leading eventually to the high courts or the Supreme Court, or now the NGT for certain matters, but the initial jurisdiction of lower civil courts is barred.
That's a massive trade-off, isn't it? Listeners should really reflect on this. On one hand, centralization allows for potentially faster, more decisive action, especially post-disaster or against major polluters.
Yes, it avoids getting bogged down.
But when you debar civil courts, doesn't that limit avenues for citizens or communities who feel aggrieved by a government order? Doesn't it potentially reduce democratic accountability and access to traditional justice systems?
That tension is absolutely inherent in the EPA's design. The thinking behind it, arguably, was that environmental issues often require specialized knowledge and rapid response, which the conventional judiciary might be slower or less equipped to provide. The legislature prioritized centralized, expert-driven environmental management.
Leading to faster implementation of crucial rules.
Potentially, yes. It has allowed for the relatively quick rollout of vital regulations under its umbrella, but you're right, it places immense responsibility and therefore scrutiny on the central government's processes ensuring due diligence, transparency, and fairness when it issues these powerful rules and notifications.
And speaking of those rules, perhaps the most significant and widely impactful regulation issued under the EPA's authority is the Environmental Impact Assessment, EIA notification.
Without a doubt. The EIA process is now the cornerstone of India's system for regulating the environmental consequences of development projects. It's been notified and amended several times under the EPA.
What does the EIA process actually require project proponents to do?
In essence, it mandates a systematic process before a project gets the final green light. It requires the collection of baseline environmental data for the project area.
What's there now?
Exactly. Then, predicting the likely impacts, positive and negative, that the project will have on the environment. Assessing the significance of those impacts, suggesting mitigation measures.
That'll reduce the harm.
Right. And a very crucial component, especially under later notifications, is the requirement for a public hearing or public consultation.
Giving affected communities a voice.
Theoretically, yes, allowing local people and stakeholders to raise concerns and objections. All this information, the data, the predictions, the mitigation plans, the public feedback, goes into an EIA report, which is then appraised by an expert committee before the final decision on environmental clearance is made.
So it forces decision makers, at least on paper, to weigh the environmental costs before implementation.
That's the objective, to integrate environmental considerations into the decision-making process for development.
Now, the EIA process itself has evolved. The 2006 EIA notification, for instance, introduced a critical element of decentralization by categorizing projects. Can you explain the difference between Category A and Category B projects?
Yes, the 2006 notification and subsequent versions tried to streamline the process, partly due to the sheer volume of projects needing clearance. It created two main tiers. Category A projects. These are generally larger-scale projects or projects located in ecologically sensitive areas, which are considered to have potentially significant national-level environmental impacts.
So big dams, major highways, large industrial estates.
Things like that. These projects require mandatory environmental clearance, and they are appraised at the national level. The appraisal is done by a Central Expert Appraisal Committee, EAC, and the clearance is granted by the Central Ministry of Environment, Forest, and Climate Change, MOEFAC, based on the EAC's recommendation.
Okay, national level appraisal for Category A. What about Category B?
Category B projects are generally smaller in scale or have localized impacts. These are appraised at the state level.
Decentralizing the workload.
Exactly. Each state is required to have a state-level Environment Impact Assessment Authority, SCAA, and a state-level Expert Appraisal Committee, SEAC. Category B projects go to these bodies for scrutiny and clearance.
Does that mean all Category B projects are cleared at the state level?
Not quite. There's a further subdivision within Category B. Category B1 projects still require a full EIA report and public consultation appraised by CSEAC. But Category B2 projects are presumed to have lesser impacts and are exempted from needing a full EIA report and public consultation, though they still need scrutiny and clearance from the CSEAC, based on prescribed criteria.
Ah, so there's nuance even within Category B. This whole EIA process stemming from the EPA's power is clearly central to the environment versus development debate in India today.
Absolutely. It's constantly debated, revised, and is right at the heart of many environmental controversies.
Okay, moving on from the broad umbrella of the EPA to acts governing specific resources. After India ratified the UN Convention on Biological Diversity, the CBD, back in 1994,
Which it hosted the COP for recently, too.
right, it needed domestic legislation to fulfill its international obligations. That led to the Biological Diversity Act of 2002.
Precisely. The BD Act was a direct consequence of that global commitment under the CBD. Its primary aim was to translate the convention's objectives into Indian law.
And what were those key objectives?
The Act explicitly lays out three main interconnected goals mirroring the CBD. 1. First, the conservation of biological diversity, protecting species, ecosystems, genetic resources. 2. Second, the sustainable use of its components, ensuring that when we use biological resources, we do so in a way that doesn't deplete them for the future. 3. And third, and this was quite groundbreaking, ensuring the fair and equitable sharing of the benefits that arise from using biological resources and any associated traditional knowledge.
That last point, the access and benefit sharing ABS aspect, is crucial, isn't it? Preventing biopiracy.
Hugely important. It aims to ensure that if commercial benefits are derived from India's genetic resources or the traditional knowledge held by its communities, then those benefits are shared back with the country and the communities who conserved or developed that resource or knowledge.
Now, managing biodiversity across a country as vast and diverse as India requires a robust structure. The Act established a complex, three-tiered institutional framework to handle this. Can you walk us through those tiers?
Yes, this three-tiered structure is key to how the Act operates, connecting national policy down to the grassroots level. 1, at the apex, you have the National Biodiversity Authority, NBA. It's an autonomous statutory body headquartered in Chennai. Its role is to advise the central government on biodiversity matters, regulate access to biological resources for research or commercial use, especially by foreign entities or for intellectual property rights, IPR, and ensure benefit sharing.
So the NBA is the main regulator at the national level.
Correct. 2. Then, at the state level, the Act mandates the establishment of state biodiversity boards, SBBs, in each state. Their role is to advise the state governments, regulate access to resources for Indian entities within the state, subject to NBA guidelines, and promote conservation and sustainable use at the state level.
Okay, national and state bodies. What about the local level?
This is arguably the most vital part of the structure. 3. At the grassroots, the Act mandates the creation of biodiversity management committees, BMCs, by every local self-governing institution, panchayats in rural areas, municipalities in urban areas.
Every single one.
Yes, that's the mandate. The primary function of BMCs is the conservation, sustainable use, documentation of local biodiversity, including preserving traditional knowledge through People's Biodiversity Registers, PBRs, and ensuring benefit sharing from any use of resources within their jurisdiction.
So the BMCs are meant to be the custodians at the very local level. And you mentioned the MBA's role regarding intellectual property. How does that work? Why is it so important?
It's the gatekeeper function, really. Section 6 of the Act states that anybody seeking any kind of intellectual property right patents, for example, based on biological resources or knowledge obtained from India, must get prior approval from the NBA.
Whether they are Indian or foreign.
Yes. This is critical to prevent what's known as biopiracy, where companies or researchers patent genetic resources or traditional knowledge from a country without permission or providing benefits. If the NBA grants approval for IPR, it must impose benefit-sharing conditions.
Ensuring benefits flow back.
Exactly. To the national fund, and ideally directly back to the communities whose resources or knowledge were used. It's about recognizing sovereign rights over genetic resources and the value of traditional knowledge.
Okay, fascinating. Now let's pivot to another critical piece of legislation, one that really tackles the social dimensions of environmental governance. The Forest Rights Act, FRA, of 2006.
Ah, yes, the FRA.
And its full name is quite revealing. The Scheduled Tribes and Other Traditional Forest Dwellers, Recognition of Forest Rights Act, 2006. The name itself tells you its primary mission.
It really does. The FRA is fundamentally an act about social justice, about democratic recognition. It aims to correct what it calls the historical injustice suffered by forest-dwelling communities.
Injustice caused by earlier forest laws.
Largely, yes. Colonial-era forest laws, and even post-independence ones like the Forest Conservation Act of 1980, FCA, tended to prioritize state control over forest lands, often extinguishing or ignoring the traditional rights of communities who had lived in and depended on these forests for generations. The FCA, for instance, heavily restricted the diversion of forest land for non-forest purposes, which was necessary for conservation, but it didn't adequately address the rights of people already living there.
So the FRA tries to reconcile conservation needs with the rights of forest dwellers. It recognizes specific rights.
Yes, it recognizes and vests various rights in eligible communities and individuals. These include individual rights, like the right to hold and live in forest land that they were cultivating prior to a cutoff date, December 13, 2005, and ownership of minor forest produce.
Minor forest produce like tendu leaves, bamboo, medicinal plants.
Exactly. Things crucial for livelihoods. It also recognizes community rights, such as grazing rights, fishing rights, rights to protect and manage community forest resources, access to biodiversity, and rights over traditional knowledge.
Now, the eligibility criteria are quite specific, especially for the other traditional forest dwellers. Who qualifies under that category?
Right. The Act covers scheduled tribes residing in forests. But for other traditional forest dwellers, OTFDs, communities who aren't scheduled tribes but have lived in forests, traditionally the criteria are stricter and time-bound.
What are they?
An OTFD community or individual must prove that they have primarily resided in the forest land for 3 generations prior to December 13, 2005.
3 generations. How is a generation defined?
The Act itself defines a generation for this specific purpose as a period comprising 25 years. So essentially, they need to demonstrate roughly 75 years of primary residence and dependence on the forest for bona fide livelihood needs before the cutoff date.
That's quite a high bar for proving historical residence.
It is, and proving it can be challenging. But the time-bound condition was included to ensure rights are granted to communities with genuine, long-standing traditional dependence rather than recent encroachers.
Okay, and arguably the most revolutionary aspect of the FRA is who holds the authority to actually determine and recognize these rights. It's not the Forest Department, is it?
Absolutely not, and this is critical. Under the FRA, the authority designated to initiate the process for determining the nature and extent of individual or community forest rights, or both, is the Gram Sabha.
The village assembly itself.
Yes, the Gram Sabha, the fundamental unit of grassroots democracy, is empowered to receive claims, verify them, consolidate them, and pass resolutions. These resolutions then go up through subdivisional and district-level committees, which include tribal welfare, revenue, and forest officials, but also elected members, for approval.
So it completely decentralizes the initial decision-making.
It aims to. It places the power in the hands of the community itself to deliberate and decide on rights claims based on local knowledge and evidence. This bypasses the traditional forest bureaucracy, which, as you noted, had often been the source of conflict and denial of rights in the past. That empowerment of the Gram Sabha is what makes the FRA potentially so transformative for forest governance in India. Now, with all these complex environmental laws, we've discussed the WPA, EPA, BD Act, Water Act, Air Act, Forest Conservation Act, enforcing them and resolving disputes requires specialized knowledge.
Right. You need expertise in science, ecology, not just law.
Exactly. And the regular civil court system, well, it often faced challenges, delays, lack of technical expertise among judges, the sheer volume of cases. This led to the realization that a specialized body was needed.
Which resulted in the National Green Tribunal, NGT, established by the NGT Act of 2010.
Precisely. The NGT was set up specifically for the effective and expeditious disposal of cases related to environmental protection, conservation of forests, and other natural resources.
Effective and expeditious, meaning faster and better informed decisions.
That's the goal. And its composition reflects this. The NGT isn't just staffed by judges. It comprises both judicial members, who are typically retired High Court judges or Supreme Court judges.
Bringing legal expertise.
Yes, and crucially, expert members. These are individuals with significant professional qualifications and practical experience in fields like environmental science, engineering, forestry, pollution control, biodiversity, etc.
A hybrid bench, combining law and science.
Exactly. This structure ensures that the tribunal's decisions are grounded not just in legal interpretation, but also in scientific understanding and technical feasibility. It's designed to provide specialized environmental justice.
Now, there's a direct constitutional link, often cited for the NGT's creation, connecting back to fundamental rights, isn't there? How does it relate to Article 21?
Yes, the NGT Act itself was framed, and is often interpreted, in consonance with the broader constitutional right to a healthy environment.
Which isn't explicitly written in the Constitution itself.
No, but through decades of judicial interpretation by the Supreme Court, the right to a healthy environment has been read into and recognized as an integral, inseparable part of the right to life under Article 21.
So, by providing a dedicated forum for speedy environmental justice, the NGT is seen as upholding this fundamental right.
That's the argument. It provides an accessible, specialized mechanism for citizens to seek remedies for environmental damage or violations, thus giving practical effect to the constitutional right to a clean and healthy environment. There's also a link sometimes drawn to Article 275(1) regarding grants for scheduled areas, but the Article 21 connection is more central.
When the NGT decides cases, it doesn't just operate on general legal principles like a civil court might. It's explicitly guided by principles of environmental jurisprudence, correct?
Yes, the NGT Act requires the tribunal to apply specific principles while passing orders or decisions. Two of the most important are, 1, the polluter pays principle.
Which sounds straightforward.
It is, conceptually. It means the entity responsible for causing pollution must bear the costs associated with preventing it, controlling it, and remedying the damage caused. The NGT frequently uses this principle to impose substantial fines or environmental compensation on polluting industries or individuals, often directing the funds towards restoration efforts.
Making polluters financially responsible.
Exactly, to the precautionary principle.
This one seems a bit more nuanced. What does it entail?
The precautionary principle essentially says that where there are threats of serious or irreversible damage to the environment, a lack of full scientific certainty should not be used as a reason to postpone cost-effective measures to prevent that degradation.
So act before you have absolute proof of harm if the potential harm is severe.
Precisely. It shifts the burden of proof, in a way. Instead of environmentalists having to prove conclusively that an activity is harmful, the principle suggests that the proponent of the activity should demonstrate that it is not harmful, especially when the stakes are high. It promotes proactive environmental protection in the face of uncertainty. The NGT also applies principles of sustainable development.
That's a powerful tool. It significantly lowers the threshold for regulatory intervention, giving the NGT real teeth. And its jurisdiction is quite specific, too, covering key environmental laws.
Yes, the NGT Act, Schedule 1, explicitly grants the tribunal jurisdiction over civil cases where a substantial question relating to the environment arises out of the implementation of 7 specific environmental laws.
Let's list them.
Okay. 1. The Water Prevention and Control of Pollution Act, 1974. 2. The Water Prevention and Control of Pollution Cess Act, 1977. 3. The Forest Conservation Act, 1980. 4. The Air Prevention and Control of Pollution Act, 1981. 5. The Environment Protection Act, 1986. 6. The Public Liability Insurance Act, 1991, related to hazardous substances. 7. The Biological Diversity Act, 2002.
But not the Wildlife Protection Act, 1972.
Interestingly, no. The WPA 1972 is not currently under the NGT's direct jurisdiction. Challenges under the WPA typically still go through the high courts. But for these 7 major environmental statutes, any significant civil environmental dispute must go directly to the NGT.
Bypassing the often slower initial stages of the regular civil courts.
Correct. Ensuring, in theory, rapid, specialized judicial review for core environmental matters covered by these acts.
Okay, let's shift gears now from the specific legal frameworks and enforcement bodies to the overarching national policy strategy for a critical global challenge: climate change.
We're talking about the National Action Plan on Climate Change, NAPCC, which was launched back in 2008.
The NAPCC. Now, to really understand India's strategy here, we need to put it in context, right? India's position is somewhat unique. Historically, and even now, its per capita greenhouse gas emissions are relatively low compared to developed nations.
That's a key point. For instance, back around 2010, India's per capita GHG emission was estimated at about 1.56 tons of CO2 equivalent.
Which was significantly less than the global average at the time.
Less than 1/3 of the world's average, yes. So while India is committed to contributing to global mitigation efforts, its primary focus, driven by its development needs and vulnerability, has often been framed around adaptation.
Preparing the country and its people for the inevitable impacts of climate change: extreme weather, sea level rise, impacts on agriculture and water.
Exactly. While simultaneously pursuing specific mitigation goals, particularly in areas like renewable energy and energy efficiency, consistent with its development path. The NAPCC tries to weave these threads together.
So what are the overarching goals of the NAPCC? What's the big picture aim?
The NAPCC aims to be India's comprehensive, long-term, integrated strategy to tackle climate change. Its core goals revolve around a few key themes: protecting the poor and vulnerable through adaptation and mitigation, achieving national growth objectives through strategies that also yield co-benefits for addressing climate change effectively.
Like cleaner energy also improving air quality.
Precisely. It emphasizes the development and use of new and cleaner technologies, promoting better understanding of climate change science and impacts, enhancing energy efficiency, and conserving natural resources. It's structured around 8 core national missions.
8 missions. These form the practical, multi-sectoral pillars of the strategy. We should probably detail each one briefly, as they cover so many critical areas.
Agreed. Let's run through them. 1. National Solar Mission, NSM. This is probably the most well-known. Its primary goal is, quite simply, to massively promote the development and deployment of solar energy across India.
For electricity generation, heating, cooling.
All of the above. The initial strategy focused on grid-connected power, large-scale solar plants, but also significantly on off-grid applications to bring power to areas without access to the grid and promoting solar thermal technologies. It's been revised and scaled up massively over the years.
Huge focus on solar. What's next?
2. National Mission for Enhanced Energy Efficiency, NME. This one aims to unlock the huge potential for energy savings in India's economy. It uses market-based approaches.
Market-based. How does that work?
A key initiative under NME is the Perform, Achieve, and Trade, PAT, scheme.
PAT. Okay, let's pause on that. How does PAT actually function? It sounds important, but maybe a bit complex.
It is complex but clever. Basically, it sets mandatory specific energy consumption reduction targets for large energy-intensive industries like aluminum, cement, thermal power plants, textiles, etc.
Okay, they have a target to meet.
Right. Now, if a designated industry unit, they call them designated consumers or DCs, overachieves its energy-saving target, it earns tradable certificates called Energy Saving Certificates, ESCerts. One ESCert usually represents 1 metric ton of oil equivalent of energy saved.
So they get rewarded for doing better than required.
Exactly. And conversely, if a company fails to meet its mandatory target, it has to purchase ESCerts from the market, from those companies that overachieved, to cover its shortfall and comply with the regulation.
Ah, so it creates a market for energy efficiency itself.
Precisely. It allows companies that can save energy cheaply to profit by selling certificates, while companies for whom saving energy is more expensive can buy certificates to comply. It drives overall energy efficiency in the industrial sector using economic incentives alongside regulation. It's quite innovative.
Very interesting mechanism. Okay, mission 3.
3. National Mission on Sustainable Habitat, NMSH. This mission tackles the environmental challenges of urbanization.
Growing cities, increasing resource use.
Yes. It focuses on several areas: improving energy efficiency in buildings, both commercial and residential, partly through the extension and enforcement of the Energy Conservation Building Code, ECBC.
Greener buildings.
Right. It also emphasizes better urban planning, managing municipal solid waste more effectively, including technologies to generate power from waste, and promoting a shift towards public transportation to reduce congestion and emissions from private vehicles.
Addressing the urban footprint. What's mission 4?
4. National Water Mission, NWM. This focuses squarely on water resources, which are under immense stress and highly vulnerable to climate change.
Droughts, floods, changing monsoon patterns.
All of that. The NWM aims to ensure integrated water resource management, conserve water, minimize wastage, and ensure more equitable distribution. Key goals include improving water use efficiency across all sectors: agriculture, industry, domestic by 20%, promoting basin-level management strategies, and dealing with the impacts of climate change on water resources.
Critical for India. Mission 5.
5. National Mission for Sustaining the Himalayan Ecosystem, NMSHE. This recognizes the unique vulnerability of the Himalayan region.
Glaciers melting, biodiversity loss, impacts on downstream water.
Exactly. The NMSHE aims to develop a robust understanding of whether and how the Himalayan ecosystem is degrading due to climate change. It focuses on building scientific and institutional capacity to continuously assess the health of the ecosystem and inform policy interventions to sustain it. It's about building knowledge and resilience in this critical mountain range.
A dedicated focus on the Himalayas. Makes sense. Mission 6.
6. National Mission for a Green India, GIM. This mission is directly focused on forests and vegetation cover. It's essentially India's major afforestation and ecosystem restoration program under the NAPCC.
Planting trees.
Yes, but it's broader than just planting trees. Its main quantitative goal is ambitious: to increase forest and tree cover on 5 million hectares of forest and non-forest lands, and simultaneously improve the quality of forest cover on another 5 million ha.
So a total target of 10 million hectares.
Correct. The aim is not just increasing area, but also improving the density and health of existing degraded forests, thereby enhancing ecosystem services like carbon sequestration, biodiversity conservation, and hydrological functions, while also supporting forest-dependent communities.
Big land restoration goals. What's Mission 7?
7. National Mission for Sustainable Agriculture, NMSA. This mission directly addresses the huge challenge of making Indian agriculture more resilient to climate change.
Which is vital given how many livelihoods depend on it and its sensitivity to weather patterns.
Absolutely. NMSA focuses on promoting climate-resilient agricultural practices. This includes developing drought-resistant crop varieties, promoting integrated farming systems, combining crops, livestock, fisheries, etc., improving soil health management, expanding micro-irrigation, and strengthening risk management tools like crop insurance linked to weather data.
Making farming smarter and safer in a changing climate.
That's the idea. For example, scaling up the use of automatic weather stations to provide localized data that can inform farming decisions and insurance payouts.
Okay, and the final one, Mission 8.
8. National Mission on Strategic Knowledge for Climate Change, NMSKCC. This mission essentially provides the research and development and knowledge-sharing backbone for the entire NAPCC.
The brains behind the operation.
Sort of. It aims to build a vibrant climate science research community in India. It focuses on strengthening capacity for modeling the impacts of climate change at regional and sectoral levels, creating networks for data sharing and collaboration between research institutions, and promoting the development of indigenous technologies for both adaptation and mitigation. It's about ensuring the entire climate strategy is informed by the best available science and knowledge.
So these 8 missions together form a really comprehensive, multi-pronged approach to tackling climate change across different sectors of the economy and environment.
That's the intent. It's a long-term plan, constantly evolving, but these missions represent the core pillars of India's National Climate Action Strategy. #tagoutro. So we've covered a lot of ground today, haven't we? We started right back at the constitutional foundation, that dual mandate introduced in 1976, Article 48A directing the state, and Article 51AG making environmental protection a fundamental duty for every citizen.
The essential starting point.
Absolutely.
Yeah.
Then we trace the legislative journey chronologically. The Wildlife Protection Act of 1972, setting up the schedules of protected areas. The pivotal Environment Protection Act of 1986, the powerful Umbrella Act born from the Bhopal tragedy, enabling rules like the EIA.
Right.
We looked at specific resource governance, the Biological Diversity Act of 2002 with its 3-tier structure, MBA, SPB, BMCs, and focus on benefit sharing, and the Forest Rights Act of 2006, a landmark for social justice, recognizing rights and empowering the Gram Sabha.
Don't forget the specialized enforcement.
Indeed. The National Green Tribunal, the NGT, established in 2010, bringing judicial and expert members together, guided by principles like polluter pays and the precautionary principle, handling cases under key environmental laws.
And finally, the overarching strategy.
The NAPCC, with its 8 core missions tackling climate change through adaptation and mitigation across sectors like solar energy, energy efficiency, water, forests, agriculture, and strategic knowledge. It's a complex but interconnected web of law and policy.
You know, listening to this timeline, what really stands out is how often major environmental legislation in India seems to be reactive, doesn't it?
That's a very pertinent observation.
The WPA perhaps spurred by declining wildlife stocks, the EPA undeniably triggered by Bhopal. It suggests that our environmental law often evolves significantly in response to crisis rather than always proactively anticipating problems.
It's often the case globally too, but yes, that pattern is quite visible in India. This reactive, often centralized evolution, like we saw with the EPA, certainly provides the necessary power for strong enforcement when needed.
But it also creates those inherent tensions we discussed within the federal structure and regarding transparency, accountability, and public participation versus centralized efficiency.
Exactly.
So as you, our listeners, continue your own exploration into this complex regulatory world, here's a final thought to mull over. We have the NGT, guided by the powerful precautionary principle, which can, in theory, halt a potentially harmful project before irreversible damage occurs, even without full scientific certainty.
A crucial safeguard.
Yet we also have the Environment Protection Act of 1986, granting immense centralized power to the government to define environmental standards and procedures, often through notifications like the EIA, which themselves become points of contention over what constitutes acceptable risk or adequate assessment.
A real tension there.
So the question to ponder is, how can civil society, communities, and indeed the legal system itself ensure that the concentrated power necessary for efficient environmental protection which the EPA provides doesn't inadvertently become an obstacle to meaningful, localized democratic participation in assessing the very projects that might affect people and ecosystems most profoundly? Finding that balance remains a central challenge. That's a deep dive for you to continue exploring.
Thanks for watching. Follow us on Telegram and Instagram. Don't forget to like, share, and subscribe.